5 seconds to go. Start. If the State Rent Act requires the giving of a particular type of notice in order to get a particular kind of relief, such a notice will have to be given. Or it may be that a landlord will be well advised by way of abundant precaution, and in order to lend additional support to this case, to give a notice to his tenant intimating that he intended to file a suit against him for his eviction on the ground mentioned in the notice. But that is not to say that such a notice is compulsory or obligatory, or that it must fulfill all the technical requirements of section 106 of the Transfer of Property Act. Once the liability to be evicted is incurred by the tenant, he cannot turn round and say that the contractual lease has not been determined. The action of the landlord in instituting a suit for eviction on the ground mentioned in any State Rent Act will be tantamount to an expression of his intention that he does not want the tenant to continue as his lessee, and the jural relationship of lessor and lessee will come to an end on the passing of an order or a decree for eviction. Therefore, it is clear that the Honorable Supreme Court has categorically opined that even if the prescribed notice is not given by the landlord, that would not in all situations defeat his petition. If in an eviction petition filed on the ground of non-payment of rent, the tenant continues to default in payment of rent even during the court proceedings, then the filing of petition itself shall be deemed to be a valid notice to the tenant. By filing the eviction petition, the landlord expresses his intention to evict the tenant by all means on the grounds mentioned therein. Therefore, it is clear that the requirement of giving notice to the tenant in the prescribed form as prescribed under subsection 2 of section 20 of the Act is only to enable the landlord to express his intention to evict the tenant in clear-cut terms by specifying the grounds mentioned in the notice. Consequent purpose of this provision is that the tenant understands in clear terms that the amount specified in the notice is outstanding against him, and that if he does not pay the same within statutory prescribed time, then he is liable to face the statutory consequences as prescribed under the Act. Hence, the provision of giving notice by the landlord to the tenant is only in the nature of abundant caution to enable parties to make themselves clear qua the issue of non-payment of rent. Therefore, this provision in itself is not a ground to defeat the eviction petition filed by the landlord against her his tenant. Stop.